Thank you for joining us. My name is Javier Delgado. I'm an attorney with Carpenter, Hazelwood, Delgado & Bolin, a law firm that provides legal services to condominiums and homeowners associations throughout the state of New Mexico. I am joined today by my colleague Vicki Sears, Vice President of Customer Relations for AAM LLC, a management company that provides professional management services to homeowners associations and condominiums throughout the state of New Mexico. This information is not intended to be legal advice, but is intended to be accurate as of the date of its recordation, May 30th, 2013. This is the third in a three-part series of the risks in failing to comply with the recently enacted New Mexico Homeowners Association Act, and we will be discussing in this particular video the risks in failing to comply with the requirement to provide a disclosure certificate in the event of a sale. In the event of a sale, the seller of a lot is required to provide a disclosure certificate to the purchaser. The law gets into real specifics about whether a homeowners association is subject to the requirements or not. So see Vicki or myself for details, but most associations will be subject to the law. The seller must obtain it from the association, and the association has 10 business days from the receipt of the request to comply with the requirement. The association is also authorized by law to impose reasonable charges for the time and expense associated with putting together the documents and other information that's necessary. Vicki, why don't you share with us your management perspective?
One of the nice parts of this disclosure requirement is the fact that it does require the association to become involved, at which point in time it can be disclosed if there are any known violations, if there are assessments or past due fines that are owed that could be collected at the time of closing. That would enable the association to recoup some of their funds. The other thing is this disclosure requirement protects both the buyer and the seller from the fact that the buyer cannot come back and say they were not aware they were part of an association, that they've received all the documents that they need in order to make an educated purchase into the association, because purchase into an association is recognized as a legally binding contract in the simple fact that the CC&Rs are a contract between the association and the homeowner.
Thank you, Vicki. From a legal perspective, here are the dangers. Again, the 10-day deadline goes by pretty quickly, and so the association needs to have a system and process and relationship in place for processing these requests. A reasonable charge isn't defined under the law, and that's something you want to work out between yourself and your board and your management professional. Also, and here's the big thing, purchasers are not liable for any unpaid assessments or fees greater than the amount set forth in the disclosure statement. So the risk is, if you blow the deadline, a seller who owes you a substantial amount of money may have a very good argument that because you failed to comply, the amount that they owed is now zero. So it could seriously complicate, if not prevent, an association from collecting monies from delinquent owners. So it's very important to comply with this requirement. If you have any additional questions, feel free to reach out to Vicki or me at the contact information listed on your screen.